Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Domestic Violence Defense Lawyer, Chicago, Illinois. Being charged with domestic violence in Chicago, Illinois can have long-lasting effects on your life and future. You may face orders of protection, felony charges, and mandatory periods in jail, especially if you have a prior conviction on your record. If you're facing a domestic violence charge in Chicago or anywhere else in the Cook County area, reach out to the experienced criminal defense lawyers at Combs Waterkotte today. We'll fight to reduce your charges or get them dismissed outright. Domestic violence lawyers in Chicago, serving all of Cook County, Illinois. A domestic violence charge in Chicago, Illinois can be a long, difficult experience. There's already a lot on the line in terms of criminal penalties, let alone the tense social dynamics that a domestic violence charge can cause. The last thing you should have to do if you've been arrested or charged with domestic violence is stress over your criminal defense. For a proven, trusted partner to guide you through the process of dealing with your Chicago domestic violence case, reach out to Combs Waterkotte. We've helped hundreds of clients deal with domestic violence charges, and our years of experience combined with our knowledge of Illinois law has taught us exactly how to tackle these cases. When you trust our firm to handle your domestic violence charges, we start off with a free, confidential consultation to get your side of the case. After we have the facts, our experienced team gets to work on building you the best legal defense we can to get your charges dismissed. Throughout, we maintain a trial-ready mindset, and we'll be ready to fight for an acquittal in court if we have to. If you're ready to secure your freedom and future and take your Chicago, Illinois domestic violence charges head-on, call 312-500-HELP today or contact Combs Waterkotte online. Whatever the circumstances of your case, we're here to help. Domestic violence definition in Chicago, Illinois. Under Illinois law, the commonly used term domestic violence is legally called domestic battery. The domestic battery statute says a person commits domestic battery when they knowingly, and without legal justification, cause bodily harm to any family or household member, touch or act toward a family or household member in a way meant to upset, offend, or start a fight. The necessity of the harm or contact occurring inside the household contrasts with Illinois' assault laws and battery laws, as those crimes must occur in a public place. Illinois law also has an aggravated domestic battery statute reserved for more serious offenses. To be charged with aggravated domestic battery, the perpetrator must cause great bodily harm or permanent disability or disfigurement to any family or household member. You can also be charged with aggravated domestic battery in Chicago for strangling a family member. What is the punishment for domestic violence in Chicago, Illinois? The standard charge for a domestic violence offense in Chicago is a Class A misdemeanor. If convicted, the defendant may spend up to 364 days in jail and have to pay a fine between $75 and $1,500. In other instances, domestic battery can be charged as a felony in Chicago, Illinois. The exact felony charge and the resulting penalties depend on the severity of the domestic violence incident. Domestic violence is a Class 4 felony in Chicago when the defendant has violated an order of protection. The defendant has been convicted of certain violent crimes in the past. The defendant has 1 or 2 past domestic battery convictions. Domestic violence is a Class 3 felony in Chicago when The defendant has 3 past domestic battery convictions. Domestic violence is a Class 2 felony in Chicago when the defendant has 4 or more past domestic battery convictions. It's also important to know that, for second and subsequent domestic battery offenses, an individual must spend a minimum of 3 days in jail. If the incident is committed in the presence of a child, the individual must spend at least 10 days in jail or do 300 hours of community service, or possibly both. The Illinois Domestic Violence Act of 1986. While the Illinois Criminal Code defines the criminal penalties for domestic violence in Chicago, the Illinois Domestic Violence Act of 1986 defines civil penalties for domestic battery offenses in Chicago. The Act outlines several civil remedies applicable to domestic violence cases, including orders of protection that prohibit contact with the alleged victim, exclusive possession of residence rules that remove the accused from a shared home, stay-away orders from specific locations, like the alleged victim's workplace or school, temporary child custody and visitation restrictions, firearm restrictions for the accused, counseling or treatment requirements, like anger management or domestic violence counseling, financial support for the alleged victim's medical expenses or damage to property. While these requirements don't directly mandate additional time in prison, they go hand in hand with criminal domestic battery offenses, and violating them could result in additional charges or longer prison sentences. What to do if you're arrested for domestic violence in Chicago, Illinois? An arrest for domestic violence in Chicago is typically a stressful situation stemming from fraught family or spousal relationships. Despite the pressure, it's important to remain calm and remember that you have constitutional rights that can help with your criminal defense. The domestic violence defense attorneys at Combs Waterkotte recommend the following actions for anyone charged with or arrested for domestic battery in Chicago, Illinois. Exercise your right to remain silent. If you're arrested for domestic violence in Chicago, one of the most important things you can do is remain silent. Do not answer questions or try to explain your side of the story to law enforcement. Anything you say can be used against you later. Invoke your right to remain silent and request an attorney immediately. Hire an experienced defense attorney. Domestic violence charges move quickly through the court system in Chicago. Hiring an experienced domestic violence criminal defense attorney as soon as possible ensures your rights are protected from the start. Your lawyer can guide you through bond hearings, challenge evidence, and begin building a defense strategy right away to improve your chances of a favorable outcome. Document everything you remember. As soon as possible after your arrest, write down everything you remember about the incident. Include details about what happened, who was present, and any interactions with law enforcement. These details can fade quickly, and having a clear record may help your attorney identify inconsistencies, locate witnesses, and build a stronger defense on your behalf. Do not interact with the alleged victim. After a domestic violence arrest, you will likely be subject to a no-contact order or order of protection. Violating this order, even by texting or calling, can result in additional criminal charges. Avoid all communication with the alleged victim, even if they attempt to contact you first. Let your attorney handle all communication moving forward. Preserve evidence and identify witnesses. If there is any physical evidence like photos, videos, or messages, make sure it is well preserved. Do not delete anything that could be relevant to your case. Additionally, find any witnesses who may support your version of events. Providing this information to your attorney early can be critical in challenging the prosecution's narrative and strengthening your defense. Follow all court orders and conditions. After your arrest, the court may impose conditions like bond requirements, travel restrictions, or no-contact orders. It's essential that you follow these rules carefully. Violating court orders can lead to additional charges or stricter conditions. Demonstrating compliance shows the court that you take the matter seriously and can help your case moving forward. Criminal defense strategies against domestic violence charges in Chicago, Illinois. Although domestic violence situations in Illinois are very serious and complicated, a criminal defense attorney can help to reduce or dismiss your charges or even fight for an acquittal at trial. Combs Waterkotte has handled domestic violence cases in Chicago before, and we've found the following criminal defense strategies to be particularly effective at fighting the charges. Duress. A duress defense in a domestic violence case in Chicago, Illinois argues that the accused acted under an immediate threat of harm and had no reasonable way to avoid the situation. If someone was forced into physical conduct due to fear of serious injury or death, a defense attorney may use this strategy to challenge criminal liability. Demonstrating credible threats or intimidation can weaken the prosecution's case by showing the defendant did not act voluntarily or with true criminal intent. Fourth Amendment. The Fourth Amendment protects individuals from unlawful searches and seizures by law enforcement. In a Chicago domestic violence case, a defense attorney may challenge whether police had a valid warrant or probable cause to enter a home, seize evidence, or make an arrest. If officers violated these constitutional protections, key evidence such as photographs, weapons, or statements may be suppressed. Fifth Amendment. The Fifth Amendment protects individuals from being compelled to incriminate themselves. In domestic violence cases in Chicago, Illinois, this defense may be used to challenge statements made during police questioning if they were obtained through coercion, pressure, or without proper legal safeguards. If a defendant's statements were involuntary or improperly obtained, a defense attorney can seek to have them excluded from evidence. Lack of intent. Domestic violence charges in Chicago, Illinois require proof that the accused acted knowingly. A lack of intent defense argues that the incident was accidental or misunderstood rather than a deliberate act of harm. For example, physical contact may have occurred unintentionally or without any purpose to injure. By highlighting inconsistencies in witness testimony or evidence, a defense attorney can create reasonable doubt about the defendant's state of mind. Miranda rights. Law enforcement must inform individuals of their Miranda rights before conducting an interrogation. In Chicago, Illinois domestic violence cases, if police fail to advise a suspect of their right to remain silent and to have an attorney present, any statements made may be inadmissible in court. A defense attorney can file a motion to suppress these statements, which may be central to the prosecution's case. Self-defense. Self-defense is one of the most common and effective strategies in Chicago domestic violence cases. It argues that the accused used reasonable force to protect themselves from imminent harm. If the defendant reasonably believed they were in danger of being injured, their actions may be legally justified. A defense attorney may present evidence such as injuries, witness statements, or prior incidents to support this claim. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.